My name is Calogero Ferrara. I am a prosecutor. I work at the office of the prosecutor in Palermo and a component of the special department for mafia crime and also for terrorism. I used to deal with this specific kind of crime, such as mafia crime, drug trafficking, trafficking human beings, extortions, and similar mafia cases. The topic of my video is the trafficking human beings, legal framework and judicial cooperation, and the headline points of the video will be a short examination of the legal framework, the general features of the trafficking human beings, the analysis of the legal framework, and an examination of some practical cases, some case study that some investigation that I personally lead here in Palermo. First of all, concerning the general features of trafficking human beings and smuggling of human beings, it is important to highlight that these are recent phenomena, less than 20 years in such strong data, and they are considered, the smuggling and the trafficking of human beings, as a side effect of the globalization of economy. They are rooted on an unlimited demand and supply. This is the reason why we talk about human goods trafficking, because the demand and the supply of the offer are basically unlimited. Which are the main feature of this phenomena? First of all, the complexity of the legal framework. In this topic, we have a combination of international, European, and national legislation concurring each other and sometimes contradicting each other. This is the reason why it would be necessary more flexible tools to effectively deal with this kind of cases. Second main problem is the balance with the human rights of the victim of the crime, the person involved in the phenomena, and third main feature is the increasing role of the organized crime in this sector. For the big earnings coming from this activity, from the also for the basically lack of risks for this kind of criminal activities, as we can see later on. The general also concerning the general features, one of the most important things to highlight is the distinction between smuggling and trafficking, and the confusion also in legislation and in the social analysis between guilty victims and not guilty victims of the crime, and consequent not relevance of the consent of the victim of the crime. Before analyzing the legislation and the legal framework of this phenomena, I want to give you some data concerning this phenomena, just to give you an idea why it's so important to try to cope with this kind of crime and try to stop them. Just to give you an idea, in 2013, almost 40,000 people arrived in Italy. 90% of them arrived in Sicily, and this is it's considered 80% of the whole arrivals in Europe from the countries of northern and central Africa. The situation changed completely in 2014. We'll see why. In fact, we at the end of this year, of the last year, we registered almost 200,000 people arrived in Italy, 90% almost in Sicily, through the so-called Operation Mare Nostrum, organized by Italian government with the support of Frontex, that is an agency of the European Union, after the shipwreck in Lampedusa occurred on the 3rd October 2013, where more than 350 people, exactly 366 Eritreans, died in a shipwreck and at a few miles from the shore of Lampedusa, a small island in the middle of the Mediterranean Sea. And this is considered, after the Second World War, the most important shipwreck never occurred in peacetime in Europe. And with this number, do you realize why it's so difficult to cope with this kind of phenomenon? But why is important to prevent regular migration? First of all, I think to avoid exploitation of irregular migrants by employers, smugglers, and traffickers. Second, to prevent the existence of marginalized groups in the society, thus contributing to social cohesion and stability. Third, to ensure that the migration is really effectively managed, and so the credibility of legal migration policies by national states can be effectively implemented. Fourth reason, to ensure satisfactory salary levels and working conditions for national workers and lawfully resident immigrant workers, which are undermined by the employment of irregular migrants. And finally, to avoid the existence of whole sector business dependent on irregular migrant labor. On the other side, to deal with this kind of phenomenon, it is also important to underline the human rights of irregular migrants. The human rights must be respected, due also not only in general terms, but with specific reference to their condition as irregular migrants. This means the adoption of safeguards during the detention, the adoption of a procedural and substantive guarantees against expulsion and protection in the return process, the access, the guarantees to ensure them the access to economic and social rights, to the regularization and the right and the recognition of rights of residents, and to recognize their asylum when all the other requirements are respected. Considering these general features, as I told you at the beginning, in this field more than in other, the complexity of the phenomenon is also based on the complexity, on the different legal sources concurring on this topic, on this matter. First of all, just to give you, I want to read you a quick list of the European Union legal documents, legal convention, the directive, the framework decision that refer to the trafficking and smuggling of human beings. First of all, the Schengen Agreement that was adopted in 1990 at the time by the I think 15 members of the European Union. Second, the Europol Convention adopted in 1995, the Amsterdam Treaty adopted in 1997, the Charter of Fundamental Rights of the European Union adopted in Nice in 2000, the Eurojust decision adopted in 2002, the framework decision on the position of victim adopted by European Council on 2001, The framework decision number 2002/629/GAI on fighting trafficking of human beings, adopted on 19 July 2002. The framework decision on European arrest warrant, adopted on 13 June 2002. The Brussels Declaration on preventing and combating trafficking of human beings, adopted on 8 June 2003, the framework decision on fighting children sexual exploitation, adopted in 2003, and the new directive number 2011/36/UE adopted on 5th April 2011, replacing the previous framework decision adopted in 2002 by a European Union. Given this European Union legal framework, on the other side, we have also a very complex UN legal framework. So the different UN Convention and Nation Convention implemented and ratified by almost all the member states of European Union. So I refer to UN Convention on Transnational Crime, signed exactly here in Palermo in 2000. The additional protocol to the UN Convention on Fighting Trafficking of Human Beings, adopted in 2003, together with the additional protocol on fighting smuggling of human beings, adopted in the same year, 2003. Plus, and this will be the last reference to my my video, I think also can refer to the trafficking and smuggling of human beings, the statute of International Criminal Court, adopted in Rome in 1998, and also the statutes of a different ad hoc UN court, such as the ICTY or the ICTR or the ICTR, the Tribunal for Crimes Committed in Rwanda, that also, where also we can find some reference to this kind of specific crime. I want to deepen the topic referring to the scope of the UN protocols. If we read the UN protocols on trafficking and smuggling human beings, we read that the scopes of the protocols are to prevent and combat trafficking in persons, to protect and assist the victims, to respect the human rights of victims, to prevent, investigate and prosecute this kind of crime, and to promote judicial cooperation between the different states where this phenomenon can be realized. But which are the definition of trafficking and smuggling? Which are the difference between the two different phenomena? Very quickly, Article 3 in both UN protocols give us the definition of trafficking and smuggling, and this definition was repeated by all the international sources and by all the national, basically with the same features, the same national sources referring to trafficking and smuggling of human beings. UN protocols UN protocol definition of trafficking at Article 3 say that the recruitment, transportation, transfer, harboring or receipt of a person by means of threat, use of force or other means of coercion, of abduction, of fraud or deception, of the abuse of a power, a position of vulnerability, of the receiving, of giving, of payment to a person having control over another person for the purpose of exploitation. I think it's important to underline this purpose of exploitation, because we'll see that this is the main difference between smuggling and trafficking. Also, the definition of exploitation is also included in the protocol. Exploitation shall include, at a minimum, the exploitation of the prostitution or other form of sexual exploitation, forced labor, of services, slavery, or practice similar to slavery, servitude, or the removal of organs. On the other side, the Article 3 of the smuggling protocol give also the definition of smuggling of migrants that shall mean the procurement in order to obtain directly or indirectly a financial or other material benefits of the illegal entry of a person in the state party of which the person is not a national or a permanent resident. In the same article, letter B, we found the definition of illegal entry shall mean crossing borders without complying with the necessary requirements for legal entry into the receiving state. The definition of fraudulent travel or identity document shall mean any travel or identity document falsely made or altered in some material way by anyone other than the person or agency lawfully authorized to make or issue the travel or identity document on behalf of a state, or improperly issued or obtained through misrepresentation, corruption, or duress or any other unlawful manner, or in being used by a person other than rightful holder. The protocol so makes reference to some specific forms of exploitation. However, the list is not exhaustive and it may include other forms as well, and the choice made by the protocols was made to extend as much as possible the definition of trafficking in person to include any possible noun or still unknown form of exploitation. As I told you, the main difference between the two phenomena is the final purpose of the criminal conduct, because the main core of the trafficking is the exploitation for one of the different scope that we have that I have already told you before. We don't have this purpose in case of smuggling. So the consent in any case, the consent of a victim of trafficking in personal exploitation shall be irrelevant where any of the means of force, threat of, coercion, deception have been used. And in any case, the recruitment, transportation, transfer, harboring, or receipt of a child for the purpose of exploitation shall be always considered trafficking in person, even if it does not involve any of the means set forth in the definition of trafficking in person. We don't have this purpose in case of smuggling. Usually, the smuggling is based on a previous request of the victim of the crime that his travel to the most the richest countries as an hope, a final hope for a better life. But also in this case, the request of the victim of the crime does not affect in any case the crime committed by the perpetrator. The request, so this is the so-called problem of the victim's agency, so the fact that sometimes the crime is committed under request of the victim, but this does not affect the criminal responsibility of the perpetrators that facilitate the illegal entry of a person in another country.